So, good afternoon, class. We already finished discussing the first paragraph of our justifying circumstances. Now we will proceed to discussing all other parts of the justifying circumstances. We will be discussing paragraph 2 until paragraph 6. So, I will be sharing my presentation with you. I hope that you were able to read the case that I have assigned you because we will be discussing that on Wednesday once we go back to the discussions on the concerns regarding the battered woman syndrome. So for today, our topic will begin with the battered woman syndrome, and we will proceed to discussing the all the other paragraphs of justifying circumstances. So we start with battered woman syndrome. So this is my presentation. So what is battered woman syndrome? So it is also actually a justifying circumstance when a woman raises the defense of battered woman syndrome. So what is it? In claiming self-defense, appellant raises the novel theory of the battered woman syndrome. Well, new in the Philippine jurisprudence, the concept has been recognized in foreign jurisdictions. So, medyo bago pala yung mabuti niya Philippines as a form of self-defense. So, it is included on the first paragraph of justifying circumstances on the provisions of self-defense. At the least, in complete self-defense, by appreciating evidence that a victim or defendant is afflicted with the syndrome, foreign courts convey their understanding of the justifiably fearful state of mind of a person who has been cyclically abused and controlled over a period of time. A battered woman has been defined as a woman who is repeatedly subjected to any forceful physical or psychological behavior by a man in order to coerce her to do something he wants her to do without concern for her rights. Battered women include wives or women in any form of intimate relationship with men. So this we've already discussed this concept under the violence against women and their children, right? So to establish battered woman syndrome as a defense, no, as a source of self-defense or justifying circumstance, it must be likewise established that the woman is actually the wife or in an intimate relationship with the victim who is a man. Okay. Furthermore, in order to be classified as a battered woman, the couple must go through the battering cycle at least twice. Any woman may find herself in an abusive relationship with a man once. If it occurs a second time and she remains in the situation, she is defined as a battered woman. So there are requisites actually to establish whether a woman could raise this battered woman syndrome as a justifying circumstance. So the following are the requisites. There is a cycle. More graphically, the battered woman syndrome is characterized by the so-called cycle of violence, which has three phases. So these three phases must be established twice. So if these three phases has been suffered by the woman once, then she cannot claim battered woman syndrome as a defense. But if she has gone through the cycle twice, dalawang beses, ikaduha, then that's the time that it is established and she will be considered or she will be defined as a battered woman. So the first phase is the tension building phase. During the tension building phase, minor battering occurs. So there's already battery. It could it could either be verbal or slight physical abuse or another form of hostile behavior. So it doesn't necessarily mean that it should be physical already at this point. It could just be verbal, no? Harassing words, the use of harsh and evil or harassing words against the woman. The woman usually tries to pacify the batterer through a show of kind, nurturing behavior or by simply staying out of his way. So during this time, the woman tries to pacify the man or tries to stay out of his way. Okay? Giniiwasan lang niya. What actually happens is that she allows herself to be abused in ways that to her are comparatively minor. So at this point, because the abuse is still comparatively minor, not as aggressive yet, so she allows herself to be exposed to that. All she wants is to prevent the escalation. So, ayaw niya lang na mas maging grabe pa yung situation of the violence exhibited by the batterer. Okay, so kaya yun, what she does is that she tries to pacify, she tries to take care of the batterer or the man, or she tries to stay away. Di rin nila hiya makikialam. This wish, however, proves to be double-edged because her placatory and passive behavior legitimizes his belief that he has the right to abuse her in the first place. So take note, no? So this legitimizes. So this actually encourages the batterer to continue to what? To to do the verbal or the slight physical abuses or any other hostile behavior against the woman. The next phase would be the acute battering incident. What happens here? During the acute battering incident is it is said to be characterized by brutality. Now the abuse becomes more severe, more destructive, and sometimes this could even result to death. The battered woman deems this incident as yet also inevitable. So she thinks that she cannot actually control this. No, it's inevitable. It's bound to happen. During this phase, she has no control. Only the batterer may put an end to the violence. So during this phase, she believes that she can no longer control the things around her, that it is only the batterer who may choose to end or stop the violence. Its nature reasons for ending it. The battered woman usually realizes that she cannot reason with him and that resistance would only exacerbate her condition. Okay, so at this point, the battered woman actually feels helpless because at the end of the day, she is now overcome by the power, by the fear, by the destructiveness of the batterer. Number three, the tranquil, loving, or at least non-violent phase. So after the acute battery, after the destructive behavior, there is a tranquil period. At this point, during this time, the couple experience profound relief. So they will feel that the relationship is peaceful again. On one hand, the batterer may show a tender and nurturing behavior. So at this point, the batterer will say sorry for what he has done. Um, he knows that he has been viciously cruel and tries to make up for it, begging for her forgiveness and promising never to beat her again. So just imagine what the cycle of violence is actually looking like, right? So there's tension building here during this part. There's already battery, but nonetheless, it's minor. Then it builds up to acute battering incident. So this is where it becomes more destructive, more and sometimes there's a lot of brutality. Not this may involve verbal and physical abuse. And at this point, the woman becomes or feels helpless that she can no longer control what is happening. And next, during this tranquil period, the couple, the tranquil loving phase, after the battering, after the acute battering, the batterer will now say sorry and try to make up for what he has done. Okay, so that is the cycle of violence. So if the woman has gone through two cycles of violence, it is now established that she may be defined or she can be defined to be having battered woman syndrome. So yun ha. Uh so that battered woman syndrome can be used as a defense or as a justifying circumstance for such as self-defense. The three phases of the cycle of violence must be present, and that the woman must have gone through that in two cycles. No, the minimum requirement is that there should have been two cycles of violence. So if the woman suffers once again from the cycle of violence, and she as a result kills her husband or the person she is having intimate relationship, uh, sh- she can actually escape liability by raising the defense of battered woman syndrome, because the battered woman syndrome is actually a valid self-defense, and it is a justifying circumstance, and the woman will not be held liable for the offense of either murder, parricide, or homicide. Okay? So the second paragraph now, let's go to the second paragraph. Anyone who acts in defense of the person or rights of his spouse, ascendants, descendants, or legitimate natural or adopted brothers or sisters or of his relatives by affinity in the same degrees, and those by consanguinity within the fourth civil degree, provided that the first and second requisites prescribed in the next preceding circumstance are present, and the further requisite in case the provocation was given by the person attacked, the one making the defense had no part therein. So there are three main characters on this one. The first one is the aggressor, the second person is the relative, and the third person, the one making the defense. Okay, the defendant. He becomes the defendant in this case. So, who are the relatives that actually can be defended? If we raise the defense of relative, if we raise it as a justifying circumstances, who among our relatives can actually be considered as relatives, and that those relatives which can actually be defended? Okay, so of course it would include the spouse, the ascendants, the parents, the descendants, the children, legitimate, natural, or adopted brothers and sisters or relatives by affinity in the same degrees, and relatives by consanguinity within the fourth civil degree. Okay, so those are the only relatives that can be considered for what? Defense of relatives as a justifying circumstance. Outside of this one, they may already be considered as strangers. Okay, so what are the requisites of defense of relatives? Number one, there should be unlawful aggression. So we've already discussed this as an element or as a requisite in self-defense. So we no longer have to discuss that. Number two, reasonable necessity of the means employed to prevent or repel it. So we've already discussed this extensively during our discussion on self-defense. So basically, they have the same definition when it comes to unlawful aggression, reasonability of or reasonable necessity of the means employed to prevent or repel the aggression. And there's just an added there's just an added requisite here. Instead of the third requisite for self-defense, which is lack of sufficient provocation on the part of the person defending himself, that is omitted. What is included here now is that in case the provocation was given by the person attacked. So, in case that the relative gave the or started the provocation, the one making a defense had no part therein. So the person who defended the relative or defending the who was defending the relative did not take part in the unlawful aggression, or did not what did not start the altercation. So he did not provoke the aggression coming from the unlawful aggressor. Okay, even if but it is also defensive relative. It can still be considered as defensive relatives or a justifying circumstance, even if the relative who is being defended here started the provocation, so long as the person making the defense did not take part in that. Okay? Next, anyone who acts in defense of persons of rights of a stranger, provided that the first and second requisites mentioned in the first circumstance of this article are present, and that the person defending be not induced by revenge, resentment, or other evil motive. Okay? So apparently, for the third paragraph, what? Unlawful aggression is still present, okay? No? And the second one, reasonable necessity of the means employed, what, to repel it. But there is a third requisite. We will establish that a little later. For now, let us define who are deemed strangers. So we've already defined who are considered as relatives. No? So now we are discussing defense of strangers, then any person not included in the enumeration of relatives mentioned in paragraph 2 of this article is considered a stranger for the purpose of paragraph 3. Hence, even a close friend or a distant relative is a stranger within the meaning of the paragraph. So, even if you know the person, okay, so the stranger here is not the literal meaning stranger, which means in basic English, a stranger is someone who we do not know, okay, whose character we do not know. But here, for purposes of criminal law, when we talk about strangers, we are actually talking about persons not considered or not listed as a relative under the revised penal code. Of course, going back to our definition of relatives, our relatives or those who are considered as our relatives are is our spouse, our ascendants, descendants, legitimate, natural, or adopted brothers and sisters, or relatives by affinity in the same degree, or relatives by consanguinity within the fourth civil degree. So take note of that, okay? So beyond our other relatives, like fifth degree relatives, because here, those who are already only considered as relative are those relatives up to the fourth civil degree. So our fifth civil degree relatives, sixth civil degree relatives, and so on are already considered as strangers for purposes of this law. Okay? So example. So an example of a defense of defensive strangers. A heard screams and cries for help. So A is a person here. When A responded, he saw B attacking his wife with a dagger. So B was attacking his own wife, okay? B's wife. So B here was attacking his wife with a dagger. So A, B, and C are not what? Are not related because the victim here is even the attacker's spouse or the attacker's wife. So A approached B and struggled for the possession of the weapon. So A is not related to the wife, but then she tried to help the wife by approaching B and struggling to get the weapon or struggling to get possession of the weapon that B was using against his own wife. So in the course of such struggle, A inflicted wounds to B. No, so here, B's wife is a stranger, is not a relative of A. So she is considered a stranger. So here, the even if A inflicted wounds on B, he will not be held liable because during the time that he inflicted such wounds, he was acting in defense of stranger or of a stranger, which which was actually B's wife. Okay, the aggressor's wife. Okay. Paragraph 4. Avoidance of a greater evil. Any person who, in order to avoid an evil or injury, does an act which causes damage to another, provided that the following requisites are present. Number 1, First, that the evil sought to be avoided actually exists. So there really is an actual evil or an actual or an imminent danger. B, that the injury feared be greater than done to avoid it. So the injury or the evil he has feared or the injury feared should be greater than what the result of such avoidance. Okay, we will have an example on this one too, so that we can actually see how this is interpreted by our courts. Third, that there be no other practical and less harmful means of preventing it. Okay, so there were no other means to prevent the greater evil. So he the person here who committed the injury um had no other choice but to commit such act or omission because of the fear of such evil. Okay, for example, a person was driving his car on a narrow road with due diligence. Take note, due diligence. The person here was diligently driving his car with due diligence and care when suddenly he saw a 6 by 6 truck in front of his car. So they were going to have a head-on collision. And take note, it was a narrow road. No? If he would swerve his car to the left, so can you imagine on his left side, he would fall into a precipice. So if he would go to the left side to avoid the truck, he would fall in a precipice. Or if he would swerve in the right side, he would kill a passerby. Now, there was someone there, a passerby. So here, he was forced to choose between losing his life because if he would swerve to the left, he would fall into a precipice and may result to his death. Okay? Or here, if he goes to the right side, he would be killing an innocent bystander. If he chooses to swerve right to avoid injury or death of himself, and because of that, as a result, he runs over and kills the passerby, his action is actually justified. Okay? Because the following requisites are present. The evil sought to be avoided actually exists because otherwise, if he does not swerve, he will have a head-on collision with the 6 by 6 truck. Second, that the injury feared be greater than that done to avoid it. Because if he will not swerve right, for example, if he will just proceed, he will have a head-on collision with the truck, and that accident may result to his instantaneous death. If he goes to the left side, the same thing will happen. He might fall in the precipice, and as a result, he might also die. So he chooses to go to the right side. Okay, so there was really imminent danger of death on his part. That's why choosing go his option to go to the right side was actually justified. That there be no other practical and less harmful means of preventing it. Because in the first place, if he goes to proceeds to on a head-on collision with the truck, there might be death on his part. If he falls to the precipice, then there might be death on his part. So there was really no other less harmful means than just to go to the right side. But in the process of going to the right side, he kills the passerby. But his actions are justified because the requisites for avoidance of a greater evil are present, and those requisites actually are necessary for justification of the crime. So in here, the person who accidentally kills another person because of that choice of avoidance of a greater evil, then he will not be held liable because avoidance of a greater evil is a justifying circumstance. Now let's go. Another example. In view of this example and the principle involved, the killing of a fetus to save the life of the mother may be held also excusable. So for example, the mother the mother is giving birth, but then she was suffering from from an illness to which may cause her death. So the doctor is left with no other choice but to choose between the life of the fetus and the mother. And in choosing the to 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 the mother, in choosing the mother, okay, the doctor will choose to what? To uphold the life of the mother. In turn, he may what? Or the fetus may be lost, okay, by inducing the labor whatsoever. So in choosing the life of the mother, the doctor here is not committing a crime. There was just no other option. There was no less harmful means of preventing the evil, which is the death of the mother. So the doctor here had no other choice but to induce the delivery, even if the fetus will not survive such delivery. Okay, so sometimes this is very common if the fetus is actually preterm. For example, instead of giving birth at 9 months, some women give birth at 6 months, 7 months, and sometimes because the pregnancy is dangerous to the woman, the doctor may now have to induce the labor of such mother, and that by inducing the labor of the mother at an earlier stage wherein the fetus may not survive, then the doctor is justified even if such act actually kills the fetus as a result. Okay, next. Let's go to paragraph 5. Fulfillment of duty or lawful exercise of right or office. Any person who acts in the fulfillment of a duty or in the fulfillment in the fulfillment of a okay, wait lang. Duty or of a right, the lawful exercise of a right, that the accused acted in the performance of a duty or in the lawful exercise of a right, or that the injury caused of or the offense committed be the necessary consequence of the due performance of duty or the lawful exercise of such right of office. For example, police officers, they were conducting a hot pursuit operation, and as a result of the hot pursuit, the they kill the accused or the criminal or the person who performed an act which resulted to the hot pursuit. Then the killing of such a criminal or accused is actually justified because the police officers here were only what? Fulfilling their duties as police officers, and they were just what? Necessary consequence of the due performance of duty or the lawful exercise of such right or office. Okay, but then again, just take note that the police officers cannot simply kill any person just because they were in a hot pursuit operation. There are standard operating procedures on these types of activities. However, just in case the police officer does um performing his duties or with due diligence, his actions are still justified even if a person is thereby killed in the operation. Okay, because he was just fulfilling a duty or a lawful exercise of a right or office. Okay, next. This one example, People versus Felipe. Lorenzo Napilon escaped from jail where he was serving sentence. Some days afterwards, the policeman Felipe de Lima, who was looking for him, found him in the house of George, armed with a pointed piece of bamboo in the shape of a lance, and demanded his surrender. The fugitive answered with a stroke of his lance. The policeman dodged it and, to impose his authority, fired his revolver, but the bullet did not hit him. The criminal ran away without parting with his weapon. The police officer went after him and fired again his revolver, this time hitting and killing him. The policeman was tried and convicted by the court of first instance of homicide and sentenced to temporal and accessory penalties. Here, the killing was done in the performance of a duty. The deceased was under the obligation to surrender and had no right, after evading service of his sentence, to commit assault and disobedience with the weapon in his hand, which compelled the policeman to resort to such extreme means, which, although proved to be fatal, was justified by the circumstance. So here, even if the accused, the policeman, was convicted in the court of first instance, or the regional trial court, when the case was elevated to the court of appeals, now the policeman was considered not liable for the crime, because what, he was merely fulfilling a duty or a lawful exercise or right of office. Okay, so his actions were actually justified, and even if it turned out that the victim here is killed, there is still a justifying circumstance under paragraph 5 of justifying circumstances, as enshrined under the revised penal code. Okay, paragraph 6, which is the last paragraph for justifying circumstances: obedience to an order issued for some lawful purpose. Any person who acts in obedience to an order issued by a superior for some lawful purpose. Okay? That an order has been issued by a superior. Number two, these are the requisites. Number two, that such order must be for some lawful purpose. And number three, that the means used by the subordinate to carry out said order is lawful. So take note of this one, okay? Because if the order is also unlawful, then this is not justified. It will not fall under justifying circumstances. For example, a police officer was ordered to execute, or to execute a warrant of arrest against a certain person. Let's say he's A. Now, A is the accused here. So there was a warrant of arrest against him. So the police officer here served the warrant of arrest to A, but then A resisted. And there was an altercation, and because of that altercation, the police officer serving such warrant in turn killed A. Okay, so even if A was killed here, the police was still justified, because number one, there was an order for him to issue the warrant, to serve the warrant of arrest. Number two, it is for a lawful purpose, because there was actually a warrant of arrest. If a warrant of arrest is issued, it's illegal. It's legal already. That the means used by the subordinate to carry out said order is lawful. So um if A actually resisted the arrest, then the police officer had to resort to certain means to execute the arrest. So if, as a result of that, of those means, he kills the person, then he is still justified, so long as those means are also lawful, and not also arbitrary. No, they really what unfair or evil, or or yun, they really what here unlawful. So take note of that. So again, going back to our justifying circumstances, please do not forget the concepts that I have told you. No, Article 11, justifying circumstances, the following do not incur criminal liability. So anyone who acts in defense of his person or right, property, provided that the following circumstances concur. First, there be unlawful aggression. Second, reasonable necessity of the means employed to prevent or repel it. Third, lack of sufficient provocation on the part of the person defending himself. Second, the second justifying circumstance, anyone who acts in defense of the person or right of his spouse, ascendant, descendants, or legitimate natural or adopted brothers or sisters, or of his relatives by affinity in the same degrees, and those by consanguinity within the fourth civil degree, provided that the first and second requisites prescribed in the next preceding circumstance are present, and the further requisite in the case the provocation was given by the person attacked, or by the relative that the one making the defense had no part therein. So paragraph 2 is about defense of relatives. Number 3, anyone who acts in defense of the person or rights of a stranger. So, provided that the first and second requisites mentioned, so there be unlawful aggression again, unreasonable necessity of the means employed, provided that the first and second requisite mentioned in the first circumstance of this article are present and that the person defending be not induced by revenge, resentment, or other evil motive. Number 4, this one is about avoidance of greater evil. Any person, in order to avoid an evil or injury, does an act which causes damage to another, provided that the following requisites are present. First, that the evil sought to be avoided actually exists. Second, that the injury feared be greater than that to avoid it. Third, that there be no other practical and less harmful means of preventing it. 5, any person who acts in the lawful fulfillment of a duty or in the lawful exercise of a right or office. Number 6, any person who acts in obedience to an order issued by a superior for some lawful purpose. Okay, so that ends our discussion on the Article 11, justifying circumstances. Soon we will moving on to discussing exempting circumstances and other circumstances affecting criminal liability. So be ready for discussion on People versus Henosa. And also on Wednesday we will start discussing exempting circumstances. So that's it for today. I hope you learned something from our discussion and I hope that you will also take down notes because definitely all the topics that we have discussed today will appear in our exam. So that's it for today. I hope that you will always be healthy and safe wherever you are. And I'll see you again in our next meeting. Good afternoon, everyone, and keep safe.